Hello and welcome to this week's edition of Wednesday Wisdom. My name is JB Hilliard, and these are periodic video segments designed to answer questions you may have about estate planning or probate or other legal concerns that may be swirling around in your head. And for this week, I'm sorry, I'm in a very silly mood. That's called sleep deprivation, ladies and gentlemen. But for this week, I thought I'd just briefly share a pet peeve of mine. But let me start by saying this. I used to teach college courses uh, in various subjects, but I primarily taught the Microsoft Office suite of software applications. And while those were considered technology classes, by and large, one of my regular mantras throughout the class was that reading is fundamental. And so that philosophy applies to all areas of our lives. And when I'm in court or even just observing court proceedings, particularly in small claims court or landlord tenant court, what we call dispossessory court, it just pains me to see the parties not be as successful as they could be simply because they did not read. So you get a court notice for an upcoming trial or hearing. Sometimes those documents are one pager, sometimes they're 2 or 3 pages. But if you get that, if you find yourself involved in some kind of court proceeding and you get this notice of hearing or notice of trial, read it, read all of it, read every line. If you're in a jurisdiction that is still conducting hearings virtually, be especially mindful of how to submit your evidence to the court. So these instructions are always included in that initial notice, or should be, but typically they're going to tell you how to do that. If you are still technologically challenged and can't quite figure out, uh-oh, speaking of court, I should have had that muted. My apologies for that. So this is how I spend some of my work days, learning lessons from watching them. But if you're technologically challenged, call the court and talk to the clerks and have them help you walk through the process of what that should look like. They are more than happy to provide whatever assistance you need to make sure you're prepared for your case. And, a lot of times these cases, where you can basically hire an attorney to help you, I understand that sometimes you don't have the resources or the desire to hire an attorney to work on your behalf. So you got to do it yourself. And that's fine. These small claims courts are designed so that you can do it yourself, so to speak, or represent yourself. But you still need to be prepared to prove your case. And part of that is making sure you're prepared with your evidence. So let me put it this way. Don't think that because you are lawyerless that you could just show up saying, well, I'm not a lawyer, so I didn't know that, judge. You know, the and don't presume that if you say something like that, that the judge will have unlimited mercy on you. Now, granted, the judges, by and large, are understanding of the fact that you are what we call pro se. You are unrepresented by an attorney and you're representing yourself. They understand that, and they're willing to work with you to to whatever extent they can without actually providing you legal advice, because they're not allowed to do that. But you still have to prove your case. You still have to come prepared to prove your case. And I can't tell you how many times in landlord tenant court, for example, where people have shown up without even a copy of their lease to prove what the monthly rental amount was, or that there even was a valid rental agreement in place. Folks have mentioned, I see this all the time, folks mentioning that, the other party, the other side has said this and this and this, and I have text messages to prove that. But then they just basically, put their phone to the camera. Look, judge, I got the text messages. No, that doesn't work. You got to figure out how to get those text messages downloaded into a workable document that you can either print out or send, scan and send to the court as your evidentiary documentation. So just to say you have it doesn't help the judge determine, what to make of your evidence. So you've got to be prepared for that. And I know, court can be a scary thing for most people, and especially if it's something you don't do every day. Shoot, it's scary enough for those who do this on a regular basis, because there's no guarantee of the final outcome. So that can cause a lot of anxiety. But you can certainly make it less scary by being more prepared. So read everything you get from the court or from the other side. If you find yourself in a litigation situation, and be prepared. Reading is still so very fundamental. So that's it for this week. Hope you got a little bit out of that if you find yourselves approaching a court appearance date. And as always, I thank you for watching, and we'll see you next time.